Hi, this is Richard Chamberlain, and welcome to the Protecting Your Family's Future podcast. This is episode number 11, and today we're going to be talking about how to plan for your incapacity. So, if you've been listening to the show for a little while, you know that the first 10 episodes we dealt with some basic estate planning issues, concepts that you need to know. Why is estate planning important? What is a will? What is a trust? What is probate? Why do you want to avoid probate? So we wanted that to be kind of an introductory dive into estate planning topics. We're now going to start talking about some specific issues that you'll need to know as you plan your estate or think about what your estate plan is already, so that you can start to make sure that your plan is going to be the right thing for you. And as I said, this first episode today, we're going to be talking about incapacity. So for a lot of people, when they think about estate planning, they think about what's going to happen when I die? Where will my assets go? Who will receive them? Who will be in charge? And they don't give a whole lot of thought to what happens if I'm incapacitated. Now, incapacity in this context is a mental incapacity. It is an inability to effectively manage your property and financial affairs because of some mental disorder, some dementia, Alzheimer's, something of that nature. So where a doctor says you're not able to manage your property and financial affairs on your own anymore. And in that case, you're going to need someone to be in place to manage those things for you. Somebody still needs to pay your bills. Somebody needs to be able to access and manage your accounts, your real estate. So part of a good comprehensive estate plan is who is going to do that for you. So a couple of different tools that are used for this. The first, and everybody needs one of these, everybody needs a general power of attorney. This general power of attorney is a document that allows the people named as the agent in the power of attorney to act for the principal, the person who has signed the document, with regard to whatever the power of attorney covers. And in a general power of attorney, it's going to cover managing bank accounts, managing stock, personal property, dealing with retirement accounts and annuities and life insurance, health insurance, taxes, legal claims, anything that needs to be done in your name. This power of attorney should give authority to that person to do those things. So that's the first tool. And as I said, everybody needs one of those. If you have a trust, then in the trust, you will name successor trustees. So in the trust originally you created, you named yourself as the initial trustee. If you're married, you and your spouse are probably co-trustees. And you also name trustees who take over if you're incapacitated. So who should these people be? Well, if you're married, in that power of attorney, in the trust, the spouse will probably be your first agent and the first successor trustee. So if you're not able to do things, then your spouse can just continue to manage things. But then if you're both incapacitated, you would need at least one other person to step in and take over those tasks for you. If you're single, then you would need to have certainly one agent, one successor trustee, and probably two, at least two, is a better idea. Because if something happens to that first named agent and successor trustee, you still need someone to be able to do things for you. So those are some things to think about as you are planning your estate. What happens if you become incapacitated? It's a really important topic that sometimes gets overlooked. make sure that you address it and think about who are the right people to do things for you if you can't do them for yourself. So thanks for being here today, and we'll see you next week. Bye.